Well, hello. Due to popular demand, I've decided to also make a U.S. Supreme Court case review to help you for the AP test. So, here we go. All right. The first case that we're going to talk about is the case that makes all these other cases important, is Marbury versus Madison. Without Marbury versus Madison, you probably wouldn't even have the following cases because Marbury versus Madison established judicial review. You remember judicial review? It's the ability of the courts to determine if an action of government violates the Constitution. Well, in this case, the Supreme Court struck down the Judiciary Act of 1789, claiming that this law, which gave the Supreme Court original jurisdiction to hear this case, was unconstitutional. Supreme Court said the Constitution is clear when the Supreme Court has original jurisdiction. Original jurisdiction. The right for a court to hear a case first. The only time the Supreme Court will hear a case first is if you have a state versus a state dispute, or a dispute with a foreign country or a foreign leader. These are issues that would go right before the Supreme Court and heard for the first time. Anyway, Supreme Court said that Congress, when it passed the Judiciary Act of 1789, tried to add another type of original jurisdiction that the Supreme Court should have, and it was ruled unconstitutional. Now that is more information than you need to know. So let's move on to the next court case, McCulloch versus Maryland. The issue here is about the creation of a national bank. And as you can see in the picture, I provided you a picture of what the national bank looks like. Of course, today we don't have a national bank. We have the Federal Reserve Board. And thank goodness we have the Federal Reserve Board to help us get out of this economic mess, providing help and assistance for banks, for businesses, the bonds and mortgage industries. The Fed has done a lot to try to ensure we have financial stability during this horrific time. Anyway, speaking of which, McCulloch versus Maryland, the question was, can Congress create a national bank? Well, if you look in Article 1, if you recall, is all about the legislative branch. Article 1, there is Section 8, which is a list of powers given to Congress. Nowhere in Section 8 does it say that Congress can create a national bank. But if you look at Article 1, Section 8, Clause 18, you will notice the necessary and proper clause. The necessary and proper clause is also called the elastic clause. Now, what does that clause mean? Congress shall make laws that are necessary and proper to carry out its express powers. Well, what are the express powers? Well, that's Article 1, Section 8, Clauses 1 through 17. Those are all the express powers. Well, nowhere does it say that Congress created a national bank in those 1 through 17 clauses. So how can Congress create a national bank? Well, it does say in those powers that Congress can levy taxes. It does say that Congress can borrow money. It does say that Congress can coin money. Well, would it not be necessary and proper to have a national bank to carry out those powers? Hence, the elastic clause comes into play, and therefore, Congress is empowered to create a national bank by utilizing the elastic clause and tying it in to those express powers. If you recall, Congress can make policies based on powers that might not be listed, but they have to be linked some way to the powers in Article 1, Section 8. All right, well, the other issue about McCulloch versus Maryland was that Maryland didn't really want to have a national bank in their state. So they decided to tax that national bank $15,000. Well, taxing the national bank $15,000 is enough to make a bank go bankrupt. So clearly, the state of Maryland was trying to destroy the national bank. So the question is, can states tax federal institutions? Well, states can tax, but the Supreme Court ruled they cannot tax federal institutions because that would violate the Supremacy Clause. You remember the Supremacy Clause? Supremacy Clause. If you have a national policy that conflicts with a state policy, then the national policy trumps or prevails over state policy. You remember how I would show you 2/5 in class? Well, that was the best I could find on the internet. So there you have it. Anyway, so when Maryland tried to tax the national bank, the Supreme Court said that, yeah, states, you do have the power to tax, but you're trying to use this power to tax to destroy the national bank and therefore violating the Supremacy Clause. Thus, states, you cannot tax federal institutions because that would violate the Supremacy Clause. And if you want to look at the Supremacy Clause today, it would also apply to marijuana legislation. States have legalized marijuana. However, the national government still has it listed as a controlled substance. So, technically, you can still be arrested and prosecuted in states for possession of marijuana by the federal government. Because according to the Supremacy Clause, federal policy trumps state policy. Now, the only way you'll get prosecuted is if you get arrested by a federal agent. All right, moving on to the next major case, U.S. versus Lopez. This case has to do with the Gun-Free School Zone Act, in which you had a young teenager arrested for going to school with a gun. Well, he got arrested by state authorities who then transferred him over to federal authorities who then prosecuted him under a congressional law called the Gun-Free School Zone Act. Well, he was convicted, but his lawyer will appeal, saying, wait a second, how does Congress have the power to pass the Gun-Free School Zone Act? Well, Congress claimed it was regulating interstate commerce. Of course, Mr. Lopez's lawyer is going to argue Congress does have the power to regulate interstate commerce, but this law has nothing to do with interstate commerce. It got all the way to the Supreme Court. The Supreme Court agreed there is no connection between regulating guns in schools and regulating interstate commerce. And the Supreme Court said, if we allow Congress to pass such laws, then there'd be no restriction on what policies the national government could actually pass. Because you could say almost anything is related to interstate commerce, and that would therefore create a unitary system, which is not what the framers of the Constitution intended when they created the Constitution. They wanted to create a federal system. So this case is significant because for the first time since the Great Depression, the Supreme Court elevated the 10th Amendment and said the 10th Amendment places restrictions on the national government. Policies dealing with gun safety in schools are policies that should be reserved for the states. You remember, police powers are powers given to the states. You remember the 10th Amendment. If you forgot, let me tell you one more time. The 10th Amendment, powers not given to the national government are powers reserved for the states. Our powers reserved for the states. Our powers reserved for the states. What kind of powers? Social, moral, and family policies, also called police powers, are the types of policies that states are responsible for, not the national government. So therefore, the Gun-Free School Zone Act was struck down as unconstitutional in 1995. Okay, now we're moving on to cases dealing with the Bill of Rights. Before we even begin these cases, let me remind you, when the Bill of Rights was first added to the Constitution as the first 10 amendments in 1791, they only protected people in the states from the national government. In other words, those liberties listed in the Bill of Rights did not apply to the states. Well, why is it today that the Bill of Rights have become accepted as liberties that not even states should violate? Well, the Supreme Court will use the 14th Amendment's Due Process Clause, which, if you forgot, starts with, no state shall deprive any person life, liberty, or property without due process of law. Well, where's there a good list of liberties? In the Bill of Rights. So there are some liberties so fundamental in the Bill of Rights that not even states should violate. Two important recent cases I do want you to be aware of. Excessive fines. Excessive fines, which is in the 8th Amendment. If you recall, most people refer to the 8th Amendment in reference to the cruel and unusual punishment liberty. Well, it also includes excessive fines. And recently, the Supreme Court said that excessive fines is also a fundamental liberty that states can't violate. More recently, just this year, 2020, Supreme Court also ruled that when juries make decisions about whether or not someone should be sentenced to death, when juries make decisions about someone's guilt, it has to be unanimous. Before 2020, some states, Oregon, Louisiana, they only required 9 out of 12 or 10 out of 12 jurors to agree for a guilty verdict. Now, just like in the federal cases, Even in state cases, juries have to agree unanimously for someone to be determined guilty. Anyway, let's move on to First Amendment. First Amendment cases in which they deal with freedom of religion. Now, clearly, First Amendment says Congress shall make no laws, obviously proving that the Bill of Rights was meant to apply to the national government. But the Supreme Court is going to make it apply to the states because freedom of religion is a fundamental liberty that not even states should violate. Now, I want you to look at these three cases that I've listed, Engel versus Vitale, Lynch versus Donnelly, and Wisconsin versus Yoder. They deal with different issues. Freedom of religion has two major clauses, and you need to make sure you understand the two different clauses. Those clauses are the Establishment Clause. You don't want the government endorsing or hindering one religion at the expense of others. And the Free Exercise Clause. Free Exercise Clause is also known as your freedom to practice your religion. Now, most cases that deal with the Establishment Clause have to do with public school cases. Occasionally, you might get a case in which you have a non-public school case and different standards will apply. Let's start first of all with Engel versus Vitale. This is the case where you had a state that required mandatory prayer in public schools. So think of after doing the Pledge of Allegiance, students were then expected to have a moment of prayer that they had to repeat in front of the class. So there was some mandatory prayer in public schools. You also had mandatory Bible reading as well. Well, the Supreme Court said this is an endorsement of religion that public schools, which are run by the state, should not be conducting. So therefore, it was struck down as unconstitutional. And the Supreme Court will later develop a test called the Lemon Test, in which it's used to determine if public schools are violating the Establishment Clause. And in short, the Lemon Test is purpose and effect. First of all, you look at the school's rule. What's its purpose? If the purpose is secular, non-religious, then it passes the first part of that test. Then you look at how that rule is being applied, its effect. If it's endorsing or hindering one religion at the expense of others, therefore it would be struck down the way it's being applied. So Lemon Test is what we use today to determine if public schools are violating the Establishment Clause. Clearly, based on that standard, what's the purpose of having mandatory prayer? Well, it's clearly religious, and therefore it's ruled unconstitutional in violation of the Establishment Clause. Now let's look at non-public school cases. I have Lynch versus Donnelly. This had to do with a nativity scene in a public park. The Supreme Court said in this case, a nativity scene, if it's by itself, it would violate the Establishment Clause. However, if a city, which is an agent of the state, decides to put a nativity scene in a public park, it must also include secular symbols of Christmas. The Supreme Court reasoned that Christmas has become a secular season that most people will celebrate even if they're not religious, and therefore as long as you include secular symbols like the snowman, Santa Claus, Rudolph the red-nosed reindeer, etc., as long as these symbols are also associated with the nativity scene, then the city can prop up a nativity scene at a public park. The Supreme Court said there are some aspects of society that are so deeply rooted in American history and tradition that it doesn't violate the Establishment Clause. All right, so that's Lynch versus Donnelly, which is a non-public school case. All right, now let's go to the Free Exercise Clause. I just covered two cases dealing with the Establishment Clause. Now let's look at your freedom to practice your religion. Now the case that they're going to ask you about is Wisconsin versus Yoder, in which children required to attend school up until they're 16. Well, the Amish have a practice of taking their kids out of school at the age of 13 to teach them vocational skills, which could be woodworking, farming, or some type of sewing that the mom might be teaching them, but they're learned vocational skills by their parents as a part of their religious practice. Well, they were in violation of Wisconsin's compulsory education law, and the question was, should Amish be forced to attend school if in support or regulation because of that regulation of Wisconsin's law? Well, here's what the Supreme Court said. Well, let's look at the Free Exercise Clause. If you apply what became known as, or what is known as a sweet test called the Sherbert test, the burden is on the government. If the government's going to punish you for your religious practice, the government has to prove it has a compelling governmental purpose to force you to do what they need you to do, even if it violates your religious practices. Well, why would the government want people to attend schools, want children to attend schools? Well, so they don't become a burden on society. Well, Amish don't become a burden on society because they're taken out of school to learn vocational skills. Therefore, the government could not prove that its purpose should be applied to the Amish, and therefore the Amish should be able to train or take their kids out of school to teach them vocational skills. So that was the ruling based on the Sherbert test in Wisconsin versus Yoder. Now, just a side note here, in 1990, the Supreme Court will allow states to use a lesser burden to determine if they can punish someone for practicing religion. It's called the Smith test, is how I like to refer to it. Basically, if it's a secular rule or a general, as long as it's a neutral law of general applicability, the states can pass that law. So in other words, as long as they're not targeting a religion, as long as it applied to everyone, then the states can pass that law and doesn't have to worry about meeting the Sherbert test. Well, let's go ahead and take a look at these two standards. Sherbert test, the government has to prove it has a compelling governmental purpose to punish you for practicing religion, versus the Smith test, which basically says as long as it's a neutral law of general applicability. Well, let's look at the Amish. Is Wisconsin's law a neutral law? You must attend school. Does it apply to everybody regardless of religion? Does it target a religion? Well, you could argue it's a neutral law that applies to everybody. So if you looked at Wisconsin versus Yoder case and you applied the Smith test, then Wisconsin could require that the Amish attend schools based on it's a neutral law that doesn't target any particular religion, but it applies to everyone. So here's what I want you to know. Using the Sherbert test, the burden is on the government to prove it has to punish you for practicing religion, versus the Smith test, which says, well, as long as it's a neutral law of general applicability, then the governments can punish you. So it's up to the states to determine which test they're going to use. Now, you might think, how confusing is that? Well, think of the death penalty. Some states do have the death penalty, some states do not. Likewise, some states use the Sherbert test, which I would say is a sweet test because it gives you as much freedom as possible. Other states use a Smith test, which allows them to punish you, allows them to more easily punish you for practicing your religion. All right, so Wisconsin versus Yoder is significant because it applies the Sherbert test, a sweet test, which gives people as much freedom as possible to practice their religion. Okay, now we're going to talk freedom of speech, about freedom of speech and freedom of the press. Keep in mind, we do have civil liberties, and many people keep saying that we have absolute liberty, and that is not correct. Liberty is meant to give you as much freedom as possible, as long as you're not hurting the freedoms of others. So, speech. You do not have absolute free speech. You cannot just say anything you want at any time. Some speech is protected, other speech can be punished. So when can speech be punished? Well, if you create a clear and present danger based on the speech that you give. Let's look at Schenck versus U.S. He was issuing pamphlets encouraging people not to register for the draft. The Supreme Court said if he encourages enough people not to register for the draft, that creates a clear and present danger that would prevent the government from raising enough troops to protect us if we're invaded. Now, the analogy they made was that what Schenck was doing was similar to falsely yelling fire in a crowded theater. Because if you falsely yell fire in a crowded theater, people are going to panic and they're going to rush to the exits and people could get hurt. Well, obviously some constitutional scholars have criticized this analogy, but I will tell you this, it actually did take place recently in Redlands, in a Redlands theater in which a preacher was arrested for basically saying this at the end of the Avengers showing, when he said this, if you were to die tonight, are you prepared for heaven? Well, after saying that, some people clearly were frightened and thought that what he was about to do might lead to violence. And so they rushed to the doors and some people got hurt. And that preacher was arrested and convicted for that speech. Because clearly, in that speech, he created a clear and present danger. All right. More recently, the Supreme Court has given us even more protections to allow us to even make speech in which we advocate maybe unpopular ideas. This is similar to what happened in Brandenburg versus Ohio in 1969, when you had a KKK leader try to have a massive rally in Ohio in which he was advocating very unpopular ideas and saying negative things about the black race and mixing of races and how the government wasn't doing enough to protect the integration of races. Well, he was arrested after he had this massive rally that was being broadcast to the media, him and his like few dozen followers. But the Supreme Court said, look, what he was advocating was an unpopular idea. However, his speech did not incite imminent illegal activity. Like if he had convinced his audience to go out and commit illegal acts and they're about to commit those acts, then he could be punished. But in this case, he was just advocating unpopular ideas. That was the Brandenburg versus Ohio case. All right. You know, sometimes you might make speech without saying anything. We call that symbolic speech. Well, the case here, there's actually two cases, but the case dealing with the public school is Tinker versus Des Moines. You have two individuals, you see their pictures, brother and sister. They were protesting the Vietnam War by wearing those black armbands, as you can see, in protest, basically claiming that they would rather have peace than to be engaged in war in Vietnam. And the principal basically told them, look, if you wear those to school, you will be suspended. Well, they did get suspended, and they challenged this policy by the principal. The Supreme Court said, look, they did not affect the positive learning environment of the school. They were simply wearing black armbands. Therefore, that speech, which is symbolic speech, is protected speech, and they can't be punished. Now, note, you can still be punished in a public school if you wear something that advocates drug use or drinking alcohol or sex acts, anything of that nature. You can still be punished for wearing something like that and refusing to remove it. Anyway, that's Tinker versus Des Moines symbolic speech. 1989, the Supreme Court also made a similar ruling out in the public sphere in a symbolic speech case dealing with Mr. Johnson, who burned the American flag. This took place in 1984 in front of the Republican National Convention. He burned the American flag, which was in violation of Texas statute, Texas law, saying if you burn the American flag, you can be punished. Supreme Court said that burning the American flag is clearly symbolic speech, and therefore a person cannot be punished for violating their freedom of speech. Or someone cannot be punished if they are practicing symbolic speech. All right, that was Texas versus Johnson. All right, finally, New York Times versus U.S. case. This is a freedom of the press case dealing with the Pentagon Papers. Some papers were actually stolen from the Pentagon and given to the New York Times, and they published those papers. And in these papers, it basically uncovered what did really happen in the Gulf of Tonkin. Gulf of Tonkin, if you recall, this was the incident in which an American ship was supposedly attacked by North Vietnamese troops. Lyndon Baines Johnson will argue that this was an unprovoked attack in front of the people, in front of Congress, to convince Congress and the people to support sending more and more troops to Vietnam. Well, the Pentagon Papers revealed that it's still not clear if that ship was actually attacked. And even if it wasn't unprovoked because the ship was in the Gulf of Tonkin, which is next to Vietnam, supporting the South Vietnamese troops in that area. Anyway, this obviously makes the government look bad because this was the incident that President Lyndon Baines Johnson used to convince Congress to provide funding and to allow more support of sending troops. They call this the blank check that he was given to send troops to Vietnam. And at the time this information was released, 1971, Nixon was president, but he didn't want that information out that the government wasn't completely truthful about what took place in the Gulf of Tonkin. Well, the Supreme Court ruled that when Nixon tried to censor or use prior restraint, that's what prior restraint is, when Nixon tried to prevent the New York Times from printing the Pentagon Papers, he was violating the First Amendment's freedom of the press. You cannot stop publication of material unless it threatens national security. And the executive branch, the government, could not prove that printing information about the Pentagon Papers would threaten national security. Therefore, the paper must be allowed to go ahead and print the Pentagon Papers despite the objection of President Richard Nixon and the administration. So that was New York Times versus U.S. That's also known as the Pentagon Papers case. The issue that's related here is prior restraint. Can the government practice prior restraint or censorship? And almost always it cannot unless it threatens national security, but that's a very rare instance. What would be threatening national security? Like maybe publishing troop movements, so where the troops are about to attack. Well, that kind of information can be censored and can be prevented from being published. All right, so that concludes your freedom of speech and freedom of press cases.